the introduction to insurance and risk and the wonderful world of claims that I want to talk to you about today. Breakfast with Brodies is all about, it's designed for law students, trainees and NQ solicitors. It's free to attend, obviously, and it covers just a range of practice areas over the coming weeks to try to help you work out what you might want to do in terms of your career. There's also different seminars you'll see on our website and also the careers events page. We're also in the process of hiring for our NQ solicitor roles within Brodies. So they are on the NQ vacancies page on the website. So please have a look there. By way of intro, my name is Carly Forrest. I'm a partner in the insurance and risk team here at Brodies. And I'm joined today by Lindsay Smith, who's a solicitor in the team and who also trained at Brodies. So she can fill you in on all of her knowledge along the way. Okay, well, what do we do? Well, just a little bit about Brodies for those of you who don't know much about us. We're a UK law firm headquartered in Scotland. We've got offices in Glasgow, Edinburgh, Aberdeen, the Highlands, Brussels, and London most recently. And I'm part of the litigation team. It's the largest litigation team in Scotland, and insurance and risk sits within the litigation department. So we sit alongside business disputes and asset recovery, or BDAR, GRC, which is government regulation and competition, and also contentious construction. And what do I mean by insurance and risk? What does that mean? Well, all businesses have insurance. The law requires, for example, that you have motor insurance, you have EL insurance if you've got employees, and all businesses face risk. And that's essentially what our client base is and the work that we do, that's where it comes from. We act for a really wide range of market-leading insurers, large and small, blue chip clients and businesses from all sectors, large and small, either self-insured or those who nominate Brodies to handle the defence of their claims. And here are the INR partners. So there's a number of sub-teams within INR. So we've got casualty, there's professional indemnity, medical negligence and shipping. And as I say on the slide, you'll see the partners who head up those teams. All of the teams are supported by a large number of hugely talented lawyers, from senior associates right down to trainee solicitors. What are all the divisions? Well, professional indemnity, so that the Profin team act for the insurers of professionals where there's allegations made against them. So that can range from other solicitors to architects to accountants, anything you can think of in terms of a profession. It's a really broad range of professionals that they act for. So as you would imagine, the subject matter of the claims is pretty wide and pretty varied. Clin-neg or medical negligence. So Duncan acts for healthcare professionals and clin-neg claims raised in the courts, as well as representing doctors, dentists in terms of fitness to practice proceedings by the professional regulators, so by the GMC and the General Dental Council. And the shipping team, as the name suggests, act for clients involved in the shipping sector. So that includes all sorts of regulatory, MCA investigations, health and safety matters, personal injury actions, a pretty mixed bag there. And we also do recoveries, and Lindsay's going to talk to you more about that later. So as I say, I'm a partner in the casualty team, so I wanted to tell you more about that and the type of work that my team gets involved in. So I think we can probably move to the next slide. And here we are. So the bulk of our work comes from defending personal injury claims, so from the very highest value claims, so involving fatalities, brain injuries, amputations, spinal injuries, to low value claims, and really everything that happens in between. What do you mean by casualty? Well, it's all sorts of claims. So it can be loss of property, it can be damage, other liabilities, personal injury, as I've said. We're ranked band 1 in the legal directories for defender personal injury. And we're involved in Scotland's key cases, including cases which have gone to the UK Supreme Court. And, as a litigator, that is really the pinnacle in terms of creating law. And I'll talk to you a bit more about that later. It's not just litigated claims. So although we sit within litigation, it's a huge amount of our work is pre-litigation matters. and representing clients in other forms of procedures, so inquiries and interactions with the regulators and criminal prosecutions. Also a lot of pre-litigation advice, and that's where the risk side of it comes in. So advisory work to clients who need advice on basically, you know, how do we follow what's required of us by the law, by our regulator, and how do we avoid claims being made? So there's a lot of defensibility work in there too. What do I mean by employer's liability? Well, as it sounds, claims made by an employee or someone akin to an employee who suffered an injury at work. And that can range from classic slip and trips to industrial disease, so asbestos, noise-induced hearing loss or repetitive strain. And in terms of litigation, you might think of it all as court work, but a lot is pre-litigation, and actually a lot of your day-to-day is investigating allegations. So that might mean, you know, going out to an accident site to find out, well, what has happened, meeting the clients, speaking with witnesses, taking precognitions, reviewing paperwork. And I suppose, Billy, being a detective, people don't always tell the truth. I will talk more about that later. And, you know, it's so interesting and varied. And, you know, to get the call, you never know what is going to happen on any given day. You get a call, a serious accident or incident has happened, and you just have to, you go and you have to be there for your clients and help them deal with it. Public liability is broader, so cases can range from, you know, customers slipping in supermarkets, people being injured on holiday, extreme sports events, soft play are quite dangerous places, it turns out. We've dealt with cases where it's alleged that people slipped on ice in car parks or potholes, all the way to exploding underground pipes, injuring someone walking by. The thing is, you may have gathered already, one of the best aspects of the job is just how varied it is and how much you can learn about different businesses and what they do. No two cases are the same. I can genuinely say that, which keeps things really interesting and varied for us. As I say, you know, you literally never know what will hit your desk. So it keeps you on your toes, keeps you at the top of your game. You can't ever become complacent in this job. And I can say I've never had to clock watch once in my whole time that I've been doing this job. High value cases, I thought I'd probably give you some examples of what I'm talking about. You know, one case we had which involved a young man who had his foot amputated in an accident at work. So, you know, the sum sued for in that case was about £3.5 million. And that included the injury element of it, but also the past and future wage loss element, services, future treatment, care, accommodation. He required different accommodation as a result of the accident. And prosthetic limbs, obviously, and he was young, so in that, you know, you're looking at projecting forward over the course of that person's life for how many limbs are they going to require, for what purpose, so working with experts on all of those matters. We had another case which involved a worker who had his leg amputated, and that one was in a piece of equipment at a recycling centre. Unknown to his employers, he was actually on a methadone program at the time, so cue lots of interesting issues there about liability and causation. Got another case which was an alleged injury to an employee who had fallen at work and suffered a traumatic brain injury, but he had gone on to develop a neurological condition. So there's lots of interesting issues in that case about the causal link between the brain injury he'd suffered and the neurological issue he'd gone on to develop, and whether the two were linked. The thing is, one of the things that I love about the job is that I don't know, maybe a frustrated doctor or something, that you learn so much about the medical side of things. You work with, you know, the best experts in their fields, and really delve into the detail of trying to understand, you know, the causation points and the medical side of things. It's really fascinating, and also, yeah, reading people's medical notes if you're nosy. Fraud, I've put on the slide. Now, you know, most claims are genuine. You do get people who are not always telling the truth. I suppose the image that comes to mind when you think of PI claims is someone hobbling in crutches to their medical appointment and then chucking them in the back of the car afterwards. That does happen. We have had cases where that has happened. I also had a case a few years ago now, and we had a chap who had been working, had injured his back, could never go back to work, he said, and the claim was pursued in the Court of Session. Now, there's lots of things that didn't add up about it, and as I say, trawled through the medical records, raised some red flags, and it just didn't add up. So we had some surveillance instructed on him, and lo and behold, he was the anchor man of the tug of war competition at the local Gallaudet, and was suing his employer, who was also at the Gallaudet. So that was one where fraud was an aspect. We've got another case where a pursuer has given 3 different versions of events about accident circumstances. Another one who was claiming his employers, saying that he had had an accident at work, but actually his employers didn't even own the place where the accident happened until 6 months later. So someone is not telling the truth. We has another case involved a pursuer who claimed to have been absent from work for 6 months, but his earnings showed that he hadn't suffered wage loss. And according to his employers, he turned up for work every day. So that is still a mystery to be resolved. Supreme Court, I've mentioned the UK Supreme Court, definitely a highlight of my career so far. That really is groundbreaking in terms of developing the law, challenging the law, and late Lady Hale was, just phenomenal to be in the same courtroom and watch her in action and see her broach her reel. Solicitor advocacy I wanted to mention, we've got our own in-house advocacy team at Brodies. So it's the only one with 2 QCs in our in-house advocacy unit. That allows us to handle all aspects of claims which we don't, our clients have the choice in terms of who they instruct. I'm a solicitor advocate, and I would encourage anyone interested in advocacy to take that step and to push forward with that. It's extremely rewarding. Clinical negligence is the next slide, I think. We also, touched upon what Duncan's team does in terms of the regulatory side, but actually within casualty, we have a lot of claims involving clin-neg. I've listed some here, but there can also be clin-neg elements to some of the injury claims. And one case I had, it was a chap who had suffered a traumatic brain injury, was admitted to hospital, discharged weeks later, subsequently developed a DVT and sadly died. And so the clinical negligence element came in to say, well, he had the initial injury at work, but was there negligence on the part of the clinicians who treated him in terms of the DVT having not been spotted or treated prior to causing his death? Tattoos, we deal with a whole range of tattoo claims, allegations of negligence with infection and scarring. One case where there was a case against the tattoo parlour for tattooing the wrong tattoo on the person. Laser tattoo removal, where that has gone wrong, laser hair removal, all of these things. And we're actually seeing quite a bit of that, I think, as these treatments take off. I think, Lindsay, you've had some experience of cases of that nature.
Absolutely. So, I mean, as Carly said, with these kind of treatments, they're very kind of new and novel, and they're developing much quicker than the legislation and the regulation is. So it's quite interesting to be involved in these types of cases. Particularly, I've been involved in a few laser hair removal cases where there's been injuries suffered based on those treatments. And again, it's quite interesting because they're very new treatments. So it's quite interesting to try and value these claims when that's not something that's been around for a very long time. So with laser hair removal, many of the machines target pigment. Therefore, a client really has to comply with the pre-treatment advice, and that's vital to the success of the treatment. So things like having a tan before you attend can cause lots of issues, and that can affect how the treatment progresses and also cause injuries. So we have quite a few cases of that nature, which are just quite novel and interesting.
Mm-hmm. It's the things you learn, the things that you think, how would you ever know that? We learn a lot of varied things. The next slide just is I'm going to touch briefly on just product liability, because it's not just a case of slips and trips and people having incidents at work. Product liability also comes into it. We had a case recently where an injury occurred as a result of an allegedly defective product. So we recently, Gemma and my team recently successfully defended Cube bikes in a case. And I think what is so important about that is, and I'll talk later about it, is the reputational side of things for the clients. So so that was a successful defence for them as a result of an allegedly defective product. And then the next slide, move on to just to talk about health and safety. So in relation to the defender PI work, there's also the health and safety side of things. So we're instructed by insurers and directly in relation to health and safety matters. Now that can be fatal accident inquiries, which I'm sure you know what they are. It's fact-finding exercise rather than adversarial in the way that criminal or civil trials might be. Been involved in some pretty big FAIs recently. There was one including the death of someone who was in care, and one recently involving the death of fishermen who had drowned following the sinking of their vessel, and the life raft had failed to inflate. We also had one involving a fire of a hotel in which 2 people were sadly killed as well. Other inquiries, UK public inquiries, so not just things that happen in Scotland, UK-wide. Infected blood inquiry, for example, is a UK-wide inquiry looking at people who were treated by, back in the 70s, infected bloods and developed hepatitis and HIV. Prosecutions, we're instructed in relation to prosecutions of companies and individuals in terms of health and safety law and breaches of the law. And also advisory work, which I touched upon at the beginning. In addition to the contentious health and safety matters, we become involved to advise our clients when they're doing transactional work. So other teams within the firm will call on us in terms of due diligence exercises to be carried out. We gave advice in relation to a space hub in terms of initial health and safety considerations for the launch exclusion zone. And as I say, due diligence, so that could be the sale of our portfolio of hotels and reviewing the health and safety position of the hotels, any claims that are outstanding. So again, just pretty varied stuff. And I'll pass to Lindsay, who's going to talk to you about recoveries.
Thank you. So we also undertake work in relation to subrogated recoveries. So that would be financial losses arising from road traffic accidents. We work for a number of big clients in this area, Enterprise and Stagecoach to name a few, amongst many others. So this work involves dealing with private individuals who've been involved in road traffic accidents. And so it can be really rewarding when you get a good result for that individual who you've worked really closely with. For example, an individual could be involved in a road traffic accident and they can suffer various financial losses. For example, their vehicle might need repaired, they may require a hire vehicle in the meantime, they might have to pay a policy excess, they might lose out on some earnings because they can't attend work when they don't have a vehicle. So there's lots of different financial losses that can occur from that. And what we would do in this type of work is try and recover those losses from the insurer of the at-fault driver. It's quite interesting being involved in this type of work because it means you get lots of hands-on court experience. Doing this type of work, I'm in court very, very regularly in lots of different courts. So that's really good. You also get lots of experience drafting court documents and kind of building up your advocacy in the oral setting and also written advocacy. So it's really good for that type of work. You also get the opportunity to manage a really large caseload of your own, so you get to kind of have autonomy over quite a large caseload, and that's really rewarding. Also, the volume of work just means you're kept on your toes. You never know what's going to come next, and you never know who you're going to be dealing with next. So it does really keep you on your toes, which is always good when you're doing that type of work. And I'll now pass you back to Carly, who's going to tell you a bit about why we do what we do.
Yep, why do we do it? Question we often ask ourselves. I think, hopefully it's come across this morning, but I think just the very varied nature of the work and the types of clients we act for It's just so interesting. I can't stress that enough in terms of the varied nature of what we do, and the cases that we become involved in. I've said here the check and balance. What do I mean by that? Well, you know, obviously the pursuer, we do defender work. There are, you know, lots of firms who will do pursuer work, and I think for me, it's, you know, it's essentially the principle is to put the person back in the position they would have been in but for the accident. So check and balance is, well, you know, genuine claims absolutely should be paid. If there's a liability, it should be admitted, and get the claim settled is better for everyone involved, including our clients. So it's testing. It's, you know, testing the case, making sure that things have been challenged and things are, you know, essentially you're assisting the court. You're making sure the court ultimately has all of the information that they need to be able to make the correct decision. Developing the law, what we do matters. It has an impact on the legal system and liabilities going forward. So, you know, we're testing the boundaries, we're challenging previous decisions. You know, it's the same rules that apply, but the facts are different in every single case. The pursuer is different, the facts will be different, the evidence will be different. So one of the things that I love about it is the strategic element of it, and the different strategy and tactics that you may have to use in every different case, depending on what the issues are. You know, I mentioned just developing the law. One of my cases was Young against McBean, and that reaffirmed the law in terms of secondary victim claims, which, you know, everyone, I'm sure you get told about it at university. But that, you know, for me, it's so interesting to be involved in, and it's, you know, you're making law. Reputational risk management. I think you can't underestimate the importance of this one, because, you know, our clients have taken years to build a reputation, which is so important to protect. So, you know, it's, when a serious incident happens, you're not just dealing with the legal issues. You might also be dealing with people who are extremely upset that something has happened to someone on their premises, to one of their employees. And you're having to be there as the sensible, rational head to think about the liability, but also to advise on, you know, from a PR media perspective, you know, what do they do to respond correctly to the situation that they are in. You know, it takes years to build a reputation, and it can be destroyed so easily. So it's so crucial and so important, the advice they're given in those early stages. You know, we have lots of examples of that where, you know, we have worked with clients who may have drafted something to go to the press. And I remember one case many years ago having a statement had been drafted by a PR company, which said that they accepted fully the findings of the health and safety executive. Now, we didn't at all. It was going to trial. So, you know, something like that just would have made them look silly. So it's, you know, things like just having the input on that side also. You know, we're dealing with real people. So, you know, Lindsay's talked about the kind of the beauty industry, and although we might be instructed by insurers, you know, it's someone's business, it's someone's livelihood, it's someone's reputation. So it really does matter in terms of what we do for them. Tangible outcomes. As I say, it's real people we're dealing with. You meet people from all walks of life, all different sectors, all different industries. And, you know, one case I had in terms of outcomes was a case involving a young person who had really quite horrific injuries. But through part of the claim, we were able to fund a certain type of treatment for her, which just wouldn't have been open to her otherwise than via the litigation and via the insurers funding it. And she went on to make a phenomenal recovery, which, you know, it turned her life around actually. And to be able to be involved in something, yes, it's a litigation, but actually to have a tangible outcome like that is fantastic for everyone involved in the case. I didn't do litigation until the second year of my traineeship, which was a long time ago. But I can honestly say I've never looked back. You know, I'm not someone who sat in my civil law lectures at uni getting overly excited about the civil procedure rules. But from the moment I started in litigation and becoming involved in real disputes involving real people and real businesses, it just all came to life. And I think, you know, there is no bigger adrenaline rush than a good day in court and winning your case. And that never goes, doesn't matter how long you've been doing it. I don't know if there, I've obviously talked quite a lot about what we do. It'd be good to, if anyone has questions, then please feel free to put them in the chat bar, or, you know, ask away. Lindsay, is it, you obviously were a trainee at Brodies, so do you want to maybe just say a few words about, you know, coming across as an NQ? Is it different as an NQ as a trainee?
Yeah, absolutely. So I did litigation as one of the seats of my traineeship. So I had a bit of a taste of it, actually, my first seat of my traineeship, and also never looked back. And I think it'll, like you said, it's that human element of litigation that just is the big selling point for me, is dealing with real people. So when the NQ jobs came out and there was a litigation position, particularly in the insurance risk team, which is just such interesting work, like you say, it's so varied, and there's so many avenues that you don't think of with insurance litigation. So it was a bit of a no-brainer to me. That was it. You know, that was going to be the job I applied for, and I really thoroughly enjoyed my traineeship at Brodies, and had a really good wide spectrum of experience. And the NQ process to transition across was great and was very, very smooth. And I suppose working with the team as well. The team in insurance risk is fantastic at Brodies, and there's just such a massive wealth of knowledge, especially with our SOLADs too. It's great to be involved in. It's a fantastic team. I've really, really, really had a great time with the process.
I know, we're glad to have you with us. We yeah, I think that's a good point about the kind of just being at Brodies, is, you know, we have so many ranked specialists, and for me it's a case of, you know, in litigation there's lots of different areas that come into different cases. So having the ability just to pick up the phone to, you know, a true expert in their field, to be able to get that advice that you need within the firm is, I think, a massive benefit for us. There's someone has asked a question: do you need experience in this area during your traineeship to apply for an NQ position? Not necessarily, no. No, I would encourage any, you know, you're an NQ, you're going to be starting out, you're going to be going, it's a steep learning curve, you know, whichever position you end up going for as an NQ. So we have a full training programs, an extremely supportive place to work. So no, you don't.
I would echo that. I did litigation in my traineeship, but I didn't do insurance risk litigation. I didn't work for this specific team. So again, I kind of applied for a job in an area that I didn't have much expertise in, and obviously got it. And I found that it's been such a supportive team to really help with learning. So I would completely echo that. And I think absolutely, if you're right for the job, you're right for the job, regardless of having had experience or a seat in that area previously.
Mm-hmm. Yeah, I agree. Okay. I don't know if we don't have more questions that anyone wants to ask now. Like, we have put our details on the slide, so if anyone does want to follow up and ask us anything, we are happy to do that. If there's something that you want to explore further, or just hear a bit more about, to help you make up your mind about what you might want to do, then, as I say, just please get in touch with us. But otherwise, thank you very much for dialing in.